Hi everyone, welcome back. We've got a brand new story to share with you. So let's begin. My name is Steven. The lawsuit papers arrived by certified mail on a Tuesday afternoon. I was finishing up work when I noticed the certified mail slip from the Postal Service. When I picked up the package the next day, I immediately saw the official court documents with my name listed as the defendant in a civil lawsuit. As I read through the papers, my initial reaction was confusion, then a sinking feeling in my stomach. The lawsuit was filed by my wife, Helen, seeking significant damages. But Helen wasn't suing anyone. Helen couldn't sue anyone. Helen had been dead for over a year. I immediately called the law office listed on the lawsuit papers. When I reached the attorney, I explained that there had to be some mistake. Helen wasn't suing anyone because Helen had died last year from complications during what was supposed to be a routine surgery. There was no lawsuit from her because there couldn't be. She was buried in Riverside Cemetery over 13 months ago. The silence on the other end of the line stretched for what felt like an eternity. When the lawyer finally spoke again, his professional composure had cracked slightly. He asked me to repeat what I had just said, clearly confused about how he had filed a lawsuit on behalf of a deceased person. What followed was the beginning of one of the most surreal and infuriating legal battles of my life. A battle that would reveal just how accurate Helen had been about her family and how far some people will go when they see dollar signs. Helen died on March 14, 2023, 2 days after what should have been a simple surgery. The surgery itself had gone according to plan, but Helen had an unexpected allergic reaction to one of the post-operative medications. Within hours, she was in anaphylactic shock. Despite the medical team's best efforts, her body couldn't recover from the cascade of complications that followed. We had been married for 8 years at that point. Helen was 34 when she died. We owned our home together, had joint bank accounts, shared everything the way married couples do. She had a small investment stake in one of the leading agrochemical companies in the country, a modest retirement account from her previous job, and that was about it. We weren't wealthy by any stretch, but we were comfortable. Helen had always been distant from her family. Her unmarried sister, Susan, and brother Caleb lived about 2 hours away. And in all the years I knew Helen, I could count on one hand the number of times they had visited or even called just to check in. But they had no problem reaching out whenever they needed something. Helen used to refer to them as leeches, always taking but never giving anything back. The funeral was small. Her siblings showed up, but they seemed more interested in asking about Helen's affairs than actually mourning her. They made some vague comments about her belongings and asked whether she had left any specific instructions about her things. I was too deep in grief to think much of it at the time, and honestly, I assumed they were just trying to process their own loss in their own way. After Helen's death, I went through the standard legal procedures. Since we were married and Helen died without a will, everything passed to me automatically under our state's intestacy laws. The house we had bought together remained in my name. Our joint bank accounts became solely mine, and I was the named beneficiary on her retirement account. I worked with a probate attorney to ensure everything was handled correctly, and within a few months, I thought all the legal matters were settled. That's why the lawsuit mail hit me like a freight train. After receiving the lawsuit papers and calling the confused lawyer, I immediately contacted the attorney who had helped me with Helen's estate. He had been recommended by a friend years earlier, and he had handled the probate process with professionalism and genuine sympathy for my situation. When I called my attorney's office in that initial phone call, his secretary, recognizing the urgency in my voice, managed to squeeze me in for a meeting 2 days later. When I walked into his downtown office 2 days later, I was still reeling from the absurdity of the situation. My attorney listened carefully as I explained the lawsuit and the alleged $10 million lawsuit. He pulled up his files from Helen's estate and reviewed the documentation we had filed over a year earlier. After about 30 minutes of reviewing papers and asking questions, he leaned back in his chair and gave me his assessment. In his opinion, this sounded like what lawyers call a fishing expedition. A lawsuit filed without solid legal grounds in hopes of pressuring the defendant into a settlement. He explained that under our state's laws, when someone dies without a will, Their surviving spouse inherits everything before any extended family members. Since Helen and I were legally married and all our major assets were jointly owned, her family had no automatic claim to anything. My attorney's strategy was straightforward. We would gather all the documentation proving our marriage, the joint ownership of our assets, and Helen's cause of death. Then we would respond to the lawsuit by demonstrating that the plaintiffs had no legal standing to make their claims. But first, my lawyer wanted to find out who was actually behind this lawsuit, because it certainly wasn't Helen. His investigation didn't take long to uncover the truth. The lawsuit hadn't been filed by Helen, obviously, but by her family. Helen's sister was listed as the primary plaintiff, with her brother as a supporting plaintiff. The lawsuit's claims were as audacious as they were legally questionable. According to the filed documents, Susan and Caleb alleged that I had unfairly taken assets that should have been part of Helen's estate and distributed among her blood relatives. The lawsuit sought damages of several $1,000,000 based on their claims about Helen's separate property and business interests. The more I read through their claims, the more obvious it became that Susan and Caleb fundamentally misunderstood how inheritance law works. They seemed to believe that Helen's death automatically entitled them to a share of her estate, regardless of the fact that she was married and we owned everything jointly. Either they had been given terrible legal advice, or they were hoping that the threat of a lengthy court battle would pressure me into settling for some amount of money just to make the problem go away. They claimed that Helen had owned property independently before our marriage that should have passed to them upon her death. The reality was that Helen had owned a small condo before we got married, but we had sold it and used the proceeds as part of the down payment for the house we bought together. All the documentation of this transaction was in our real estate records. They alleged that certain business investments were solely in Helen's name and, therefore, should be considered separate property. This was referring to Helen's small stake in the agrochemical company. But that investment had been made with money from our joint savings account during our marriage. I had the bank records to prove it. Perhaps most offensively, they claimed that I had manipulated Helen into changing her will to exclude her family. The problem with this allegation was that Helen had never had a formal will in the first place. She had died intestate, which is exactly why the standard inheritance laws applied. Laws that give everything to the surviving spouse when there are no children involved. They also claimed that various bank accounts and retirement funds should be split among family members rather than going entirely to me. Again, this showed a fundamental misunderstanding of how beneficiary designations and joint accounts work. Helen had either listed me as the beneficiary on her retirement accounts or we held the accounts jointly. There was documentation for all of this. My lawyer suspected that Susan and Caleb had consulted with a lawyer or someone who had either given them completely incorrect information about their rights or had encouraged them to file a nuisance lawsuit, hoping to pressure me into settling for some amount rather than fighting a prolonged legal battle. The first court date was scheduled 2 months from the day I got the lawsuit. My lawyer had appeared before the judge who was assigned to the case on several occasions. My lawyer's strategy for the initial hearing was simple. Present clear, undeniable documentation of my marriage to Helen, proof of joint ownership of our assets, and evidence that Helen had died without a will, making the inheritance laws straightforward to apply. On the first hearing, Susan and Caleb's attorney presented their case first. His presentation was surprisingly vague, focusing more on general principles about family inheritance rights than on specific evidence supporting their claims. He spoke about the importance of blood relatives having access to a deceased person's estate and suggested that I had acted too quickly to transfer assets after Helen's death. When my lawyer presented our counterargument, the difference in preparation was immediately obvious. He had brought Helen's death certificate, our marriage certificate, property deeds showing joint ownership, bank records demonstrating joint accounts, and beneficiary designation forms from Helen's retirement accounts. Everything was organized, documented, and legally sound. The judge allowed the case to proceed to the discovery phase, but her questions to my Susan's lawyer suggested she was already skeptical of the plaintiff's claims. She asked specifically what evidence they had to support their allegations about separate property and whether they understood the legal implications of Helen dying intestate while married. Walking out of that courtroom, I felt frustrated that I was having to defend my legal right to inherit from my own wife. The emotional toll of reliving Helen's death while simultaneously fighting her family in court was exhausting. But my lawyer was confident that once we got through the discovery process, the case would collapse under the weight of the evidence. The discovery phase ran for months, and it was during this period that the case took a much more serious turn. My lawyer approached the discovery process with characteristic thoroughness, requesting all documents that Susan and Caleb's side claimed supported their allegations. The first red flag appeared early when we received copies of documents that Susan's legal team claimed proved Helen's separate ownership of certain assets. My lawyer immediately noticed that several of these documents didn't match the official records held by the county recorder's office. A property deed allegedly showing Helen's individual ownership of an investment property had details that didn't align with the actual recorded deed. My lawyer consulted with a forensic document examiner he had worked with on previous cases involving questionable paperwork. The examiner specialized in detecting document forgery and alteration, particularly in cases involving digital manipulation of official records. His analysis was damning. The property deed provided by Susan's team showed clear evidence of digital alteration. Someone had taken a legitimate document and modified key details, including ownership percentages and dates. Bank statements that purportedly showed Helen maintaining separate accounts had similar signs of manipulation, and the signatures on several documents didn't match authenticated samples of Helen's actual signature. During the discovery process, my lawyer learned that Susan and Caleb had been contacting Helen's former business associates, falsely representing themselves as Helen's legal heirs. They had attempted to redirect a small quarterly payment from Helen's investment and had tried to claim a modest life insurance benefit through Helen's former employer that listed me as the sole beneficiary. My lawyer realized we were no longer dealing with a simple civil dispute over inheritance rights. Susan and Caleb had crossed the line into criminal fraud territory by forging documents and making false representations to third parties in an attempt to steal assets that legally belonged to me. My lawyer made the decision to contact the district attorney's office. A detective who specializes in financial crimes and fraud cases was assigned to investigate the potential criminal violations. The detective reviewed the evidence of document forgery, false representations to businesses, and attempted theft by deception. Once the criminal implications became clear, Susan and Caleb's attorney withdrew from representing them due to the ethical complications. Susan and Caleb were forced to find new representation and hired a criminal defense attorney who had the unenviable task of defending clients who appeared to have committed multiple felonies. My lawyer's strategy shifted dramatically. Instead of simply defending against a civil lawsuit, we were now actively pursuing criminal charges against Susan and Caleb. He advised me that we should pursue this case to its full conclusion, both to ensure justice for Helen's memory and to prevent Susan and Caleb from attempting similar schemes in the future. The more I learned about what Susan and Caleb had been doing behind the scenes, the more I realized that Helen had been absolutely right about her family. They truly were leeches, and they had been planning this scheme probably since the day Helen died. The final court hearing took place on December 8, 2024. The judge had reviewed all the evidence collected during discovery, including the forensic analysis of the forged documents and the detective's investigation into the criminal fraud allegations. My lawyer's presentation was comprehensive and devastating. He walked through the clear chain of titles showing joint ownership of all major assets, presented our marriage certificate and Helen's death certificate, and methodically dismantled every claim Susan and Caleb had made. The evidence of document forgery was particularly compelling. Their old lawyer had withdrawn from a case earlier, and the new lawyer, the public defender, was left trying to defend the indefensible. His strategy seemed to focus on characterizing the forged documents as misunderstandings rather than intentional fraud, but the evidence was too overwhelming to support that interpretation. The judge's ruling was swift and unambiguous. She dismissed the lawsuit with prejudice, meaning Susan and Caleb could never refile the same claims. More significantly, she referred the case to the district attorney's office for potential criminal prosecution, noting that the evidence strongly suggested that the plaintiffs had committed multiple felonies in pursuit of their fraudulent claims. Susan and Caleb's reaction to the criminal referral was visible shock. Throughout the civil proceedings, they had seemed confident that the worst-case scenario would be losing the lawsuit. The possibility of facing criminal charges for document forgery and attempted fraud clearly hadn't occurred to them. Based on the judge's ruling and the strength of the evidence, my lawyer recommended that we file a counter-lawsuit against Susan and Caleb for damages, legal fees, and emotional distress. Months after the ruling, we filed suit seeking compensation for the $38,000 in legal fees I had incurred defending against their frivolous lawsuit, plus additional damages for the emotional distress of having to fight Helen's family while still grieving her loss. Meanwhile, the district attorney's office filed criminal charges against both Susan and Caleb. The charges included document forgery, attempted fraud, and theft by deception, all felonies that carried potential prison sentences. Faced with overwhelming evidence and the prospect of serious jail time, Susan and Caleb's new attorney began plea negotiations almost immediately. The criminal charges changed everything about Susan and Caleb's attitude toward the situation. Suddenly, the same people who had been aggressively pursuing a $10 million lawsuit were desperately trying to reach out to me to apologize and settle the case. Susan called my house multiple times, leaving voicemails claiming that the whole thing had been a misunderstanding and that they just wanted to put the situation behind them. The phone calls were revealing in their desperation. Susan claimed that they had been given bad legal advice and that they never intended to commit fraud. She offered to pay my legal fees if I would ask the district attorney to drop the criminal charges. Caleb sent a letter through his attorney claiming that he had been misled by Susan and that his involvement had been minimal. None of these appeals changed the fundamental facts of the case. Susan and Caleb had forged documents, made false representations to businesses, and attempted to steal assets that legally belonged to me. Their belated apologies didn't undo the months of legal battles, the emotional distress, or the dishonor they had brought to Helen's memory. 3 months later, we reached a settlement on the civil case. Susan and Caleb agreed to pay all my legal costs, plus additional damages for emotional distress. The total settlement was $45,000, enough to cover my expenses and compensate me for the months of unnecessary legal battles. The resolution of this case provided a sense of closure, but it also confirmed everything Helen had told me about her family over the years. Susan and Caleb had shown no interest in Helen while she was alive, rarely calling or visiting, and never offering support during her illness. But the moment she died, they saw dollar signs and were willing to forge documents and commit fraud in pursuit of money they had no legal right to claim. This experience taught me several important lessons about the intersection of grief, family dynamics, and legal rights. When someone dies, especially someone with assets, it can bring out the worst in people who feel entitled to something they have no legal right to claim. The combination of grief and money can lead to situations that would be unimaginable under normal circumstances. I also learned the importance of proper documentation and having competent legal representation. If I hadn't kept meticulous records of our joint assets and hadn't hired my lawyer to handle both the original estate proceedings and the subsequent lawsuit, this situation could have been much more complicated and expensive. My lawyer's thoroughness in discovering the document forgery transformed what could have been a prolonged civil dispute into a clear-cut case of criminal fraud. For anyone facing a similar situation, my advice is to understand your legal rights under the law and to maintain clear documentation of jointly owned assets. If you're married, the laws in most states strongly favor the surviving spouse, but you need to be able to prove your legal relationship and the ownership status of your assets. Don't assume that family members will respect legal boundaries, especially when significant amounts of money are involved. Most importantly, don't be afraid to fight for what's legally yours, even when you're grieving. Susan and Caleb were counting on my grief and desire to avoid conflict to pressure me into a settlement. They assumed I wouldn't have the energy or resources to fight a prolonged legal battle while dealing with the loss of my wife. They were wrong, and their miscalculation cost them dearly. The legal system, for all its flaws, worked exactly as it should have in this case. Clear laws, thorough documentation, and competent legal representation prevailed over forgery, fraud, and frivolous litigation. Justice was served, Helen's memory was protected, and Susan and Caleb learned that there are serious consequences for attempting to profit from someone else's death through illegal means. Today, several months after this legal battle concluded, I can look back on the experience with a mixture of satisfaction and sadness. Satisfaction that justice was served and that Helen's wishes were ultimately respected. Sadness that her family chose to dishonor her memory in pursuit of money they had no right to claim. But most of all, I'm grateful that Helen never had to see how low her family was willing to stoop. She deserved better than Susan and Caleb. Thank you for watching.